Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Kevin Estevez, an Arizona construction lien law expert. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Kevin Estevez.
Thank you, Jesse, and good morning, everyone. We are going to talk, as Jesse said today, about what happens after I record my lien and how do I get paid. And that's a question that often comes up with folks in the construction industry. Everyone has been schooled a lot of times on making sure you preserve your lien rights and getting your lien recorded. And then there's kind of a knowledge gap I've experienced after that point. What happens next? And so that's what we're going to talk about today. If you have any questions during the course of today's webinar, please use the chat box on the right. We'll save all the questions to the end and we'll answer them at that point. Please do not include any company names or any specifics in questions. Keep them general, and we'll try to answer them the best we can at the conclusion of the webinar. So with that, let's jump in. First slide here is a recap on issues we covered this year and in the past. And specifically, I want to talk about how you preserve your lien rights in Arizona. First and foremost, the thing you have to do, and probably the most important thing that you'll hear me repeat in these webinars, is timely serve a proper preliminary 20-day notice. Except for laborers for wages, every mechanics lien claimant in Arizona must serve a preliminary 20-day notice. And if you don't serve a 20-day notice, you forfeit your lien rights. If you serve an untimely 20-day notice, you forfeit a portion of your lien rights. So you can go back to previous webinars that we've done, and you know, I won't go through all the steps on how to properly serve a 20-day notice and how to timely serve a 20-day notice at this time. But you can go back to our previous webinars and those have been covered. But that's critically important that if you're going to preserve your lien rights in Arizona, you got to serve a 20-day notice. Second thing to remember in preserving your lien rights: don't forfeit your lien rights by signing an improper and or incorrect lien waiver. And that's an issue we've covered in the past as well. Be careful when you're signing lien waivers. Arizona provides 4 statutory forms that we've covered in the past. You have conditional progress waivers, you have unconditional progress waivers, you have conditional final waivers, and you have unconditional final waivers. And statutes provide the language that is required to be in those notices, and provides the circumstances in which you use them. Like I said, we've covered those issues in the past, but that's another thing. If you want to make sure your lien rights are preserved, be careful. It's critical that you be careful when you're signing lien waivers. And then the last step that we'll talk about here as a recap is timely record a statutorily compliant notice and claim of lien with the county recorder where the project is located. And our previous webinars have also covered that issue. You need to record a lien timely, and I won't go through the details on that again here in detail, but you got to record a timely lien if you want to preserve your lien rights, or else your rights will be waived. So with that, let's talk about what the meat and potatoes of today's webinar is going to be, and that's what happens after I get my lien recorded. So this is, you've served your 20-day notice properly, you've preserved and you've paid careful attention when signing lien waivers, so you've preserved all your rights there, and then you've timely recorded your notice and claim of lien. What happens next? Well, what happens next is typically in the practical world, recording a lien is another point for negotiation with either the general contractor or the owner or parties upstream on the project. And a lot of times that happens if after you do the very first thing that's reflected on the slide here is after you record your lien, you must timely serve the lien. You also need to be on the lookout for lien discharge bonds. That can affect the strategy for moving forward after a lien is recorded. Then you must sue to foreclose the lien within 6 months of recording. And then you must record a Lis Pendens within 5 days of filing suit. And we're going to dive into each of those subjects in a little more detail. And so first, serving a notice of claim lien. And as the slide says here, pursuant to ARS 33993A, lien claimants are obligated to serve copies of their notice and claims of lien on property owners within a reasonable time of recording. The term serve requires a service made by first-class mail, registered or certified mail, with the sender obtaining a certificate of mailing, receipt of registration, or receipt of certification. So you can serve it by mail, but it's got to be by first-class registered or certified mail with the sender obtaining a certificate of mailing, receipt of registration, or receipt of certification. And then you may also serve it in the same manner that process is served in Arizona, which is typically done by process server. So mail it according to what Old Adobe says here, or serve it by a process server, and that's how you get your lien served. The phrase "a reasonable time of recording" is not defined in Arizona law. So when the statute says that the lien must be served within a reasonable time of recording, the reasonable time of recording is not defined. It's viewed on a case-by-case basis, but it's one of those things where there's really no incentive to wait. It's one of those things where you get your lien recorded, you want to serve it as quickly as possible. I mentioned at the outset about discharge bonds. After a notice of claim and lien is recorded, the property owner has the option to post a lien discharge bond under 33-1004, and it must be recorded in the project, in the county where the project is located and served on the lien holder. The lien discharge bond discharges the lien on the property. So once the bond is recorded, the lien claimant, their target for purposes of a lawsuit or collection shifts from a foreclosure on the mechanics lien to a claim on the bond. If a lawsuit is already pending, the lien claimant must amend the suit to add a claim on the bond. If a lawsuit is not yet pending when the discharge bond is recorded, the lien claimant must file suit against the bond within 6 months of recording its notice of claim of lien. And the important point there is, the time frame to record or to file suit on your lien is not changed by the posting of a discharge bond. Still have that 6-month window. It's still critically important that you file suit on a lien or discharge bond claim within that 6 months of recording. Next slide here deals with the mechanics of a lien foreclosure lawsuit in Arizona. What a foreclosure lawsuit does is ask the court to order the sale of the property to satisfy the liens. Mechanics lien claimants are required to prove the validity of their lien and the value of the materials or services provided. It is, and we've talked about this in previous webinars, contractors and material suppliers and folks that need to get paid for the labor or materials they furnish to construction projects have several different avenues they can pursue in Arizona to obtain recovery from breach of contract actions, maybe complaints with the Arizona Registrar of Contractors, and there's pluses and minuses to all of those. But without question, the most effective is the recording of mechanics liens and preserving your lien rights, and that's because of what I just discussed. I mean, you have if the lien is recorded and you sue to foreclose, it's an action to sell the property, and that gets folks' attention in a way that other potential avenues of recovery don't. So as I said before, the lawsuit to foreclose on the lien must be commenced within 6 months of the lien being recorded. If no foreclosure action is filed within the 6-month window, then the lien expires by operation of law. Necessary parties to sue in a foreclosure lawsuit are essentially all others holding an equal or an inferior interest in the property, and that's something to consider as for best business practices. If you record a lien and the lien, the recording itself does not result in payment being made to satisfy the obligation, and you're getting to the point where you're think you're going to have to sue to foreclose on that lien, you want to give the folks, the attorneys that are helping you in that process sufficient time, because a lien foreclosure lawsuit is not one that can just be whipped up overnight. There's certainly some research that needs to go into preparing the complaint and specifically identifying the proper parties. And so, as I said, you need to sue to foreclose against all those holding an equal or inferior interest, and this includes other lien claimants on the same project. And typically, the way that's done to ensure that all the right parties are named is the attorneys that are preparing the lawsuit will obtain what's called the litigation guarantee from a title company, and it's essentially a title report that identifies all those with an interest in the property. And so that takes time. It's not something that can be done overnight. So, if you take one thing away from this, if you're in a position where you think you're going to have to sue to foreclose, you want to get the file over to the attorney that's going to help you with that process sufficiently in advance of the deadline to sue to foreclose. Be careful with lenders. So in most instances, lenders in Arizona will have a superior interest in the property than lien claimants, but maybe not. And it's an issue of priority, and that priority is determined largely based on when the lender's loan was put in place. If the loan was secured before construction work began, and in certain other circumstances, then the lender is going to have priority over the lien claimants. If the work progressed before the loan was secured, put in place, then in those circumstances, lien claimants may have priority over the lender on the property. But those are all issues that the attorney that's helping with the lien foreclosure lawsuit will be evaluating. But just know that generally speaking, in Arizona, lenders have superior interest. So with respect to lien claimants, claimants with valid lien rights share in the proceeds of a sale pro rata. And one thing to remember on this is that the priority of lien claimants is all the same. They all attach from when work started on the property. So there's no competing priority in terms of who gets the lien filed first, who gets it recorded first, and things of that nature. Lien claimants have equal priority, and that's why the proceeds of the sale would be split among the lien claimants pro rata. And then another thing to keep in mind in a foreclosure lawsuit is that courts may award the successful party its reasonable attorney's fees. Another aspect of a lien foreclosure lawsuit is a Lis Pendens. Must be recorded within 5 days of filing suit. That's addressed in 33-998, which refers to ARS 12-1191A. And what a Lis Pendens is a notice of pendency of action that is designed to provide general notice that a lawsuit is pending that affects title to the subject property. So that's another requirement of the statutes, is that you not only have to get your lien recorded in a timely fashion, you don't have to sue within that 6 months, but even suing within that 6 months is not good enough, because after that you still have 5 days of filing suit to get that Lis Pendens recorded. So that's another necessary step that'll happen after your lien's recorded and when you start the foreclosure process. Supposing that the lien is either satisfied after it's recorded through negotiation, or you sue to foreclose, and the foreclosure lawsuit results in a resolution of the lien claim. What happens next is you have to record a release of lien. As set forth in the slide here, pursuant to ARS 1006A, when a claimant's lien has been satisfied, the claimant shall, within 20 days after satisfaction, issue a release of lien. And then, pursuant to another subsection of that statute, failure to provide such a release subjects the lien claimant to person to liability in the amount of $1,000 and or also to liability for actual damages. So once your lien is satisfied, it's important to record, again, in the county where the lien is recorded, that release of lien document, so that lien gets off the title of the property and you don't face potential consequences under ARS 33-1006. And with that, I know we moved kind of quickly today, but that's a general overview of what happens after a lien is recorded, and how you obtain payment through the foreclosure process.
Well, thank you so much, Kevin, for that webinar. That was great. We do have a question that has come through. It says, can a lien be contested by the owner? And if a lien is contested, does it affect my deadline to move forward with the foreclosure lawsuit?
I'm not sure specifically what is meant by contested. Yes, the owner can, and hopefully one of the I guess overarching messages from these webinars will be that lien law in Arizona is incredibly detailed, and there's potential for mishaps at numerous points along the way in perfecting your lien rights, securing those lien rights, and suing to foreclose. So yes, an owner can and oftentimes will get a lien and then say, hey, there's a problem with this lien for reasons X, Y, and Z. And in that circumstance, you want to, as the recipient of a communication from the owner on that, look at and evaluate the lien that was recorded. You may have, depending on when you recorded your lien, you may have time to correct the deficiency by releasing the previous lien and recording a new one, and so if you do that, then the time to sue to foreclose would be 6 months of recording from the new lien being recorded. If you get a correspondence from an owner on a project and they say, hey, this lien is bad, and you go through and you say no, their arguments don't have merit, then that in that circumstance, and you decide to push forward with a lien that's already been recorded, contestation from the owner there would not affect your 6 months to foreclose. So that's a long way of saying it depends, and it may, but it depends on what the issue the owner raises and how you respond to that issue.
Okay, perfect. Well, thank you so much for that clarification. Another question that came through, and I believe you've already covered this in the presentation, so hopefully it will be an easy one for you. It is, what is the deadline once a lien discharge bond was filed?
Yeah, so the deadline, once a discharge bond is filed, is to suit, if no suit's pending, the deadline remains the same as as um, as it would be to foreclose on the lien. So it's that 6-month window. So
Perfect.
you record a lien on the property, you haven't sued to foreclose yet, a discharge bonds is put in place, the duration to sue remains 6 months from the recording of the lien.
All right, wonderful. Well, I believe that is all the questions that have come through so far. If you feel like you have another question that wasn't addressed, please feel free to reach out to us and we'll be sure to answer any questions as quickly as possible for you. Can you go to the next slide for us, please?
Sure.
All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's project information sheets that you can utilize at the onset of your projects and make sure you're getting as much information as possible from your customer to better protect yourself down the road. There's deadline calculators. There's so much on there, so please check it out. And help yourself out and stay organized. The next slide, if you don't mind, please. All right, so our next webinar with Kevin is going to be how to get the bonding company to pay, and that's Friday, December 13th. So sign up for free at sunraynotice.com/education. We'd love to see you guys there. And then the next slide, if you don't mind. All right, if you don't mind,
Sorry.
Thank you. No, it's okay. If you don't mind, take a moment to give us a review on Google. We'd really appreciate it. It takes about a minute of your time, but it helps other contractors like yourselves to hear about us. You can give us some feedback on the webinar, tell us other topics that you potentially would like to hear about and learn about. So please give us that review. We'd appreciate it. All right, and then the next slide. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar. Again, thank you so much, Kevin. You really are wonderful. I hope you all have a beautiful and sunny day. Thanks again, everyone.